All right. Okay, we are live.
Great, great.
There are people coming in now.
All right.
Okay, you give people a moment to come in. Welcome to Learn How to Protect Your Intellectual Property live discussion. Hosted by Mr. James Peterson, Vice President and Small Business Ambassador from M&T Bank. And featured guest, Tariq Najee-Ullah, Registered Patent Agent and Strategic IP Consultant with Patent Insider. And this is being presented by the SBRC, City of Baltimore.
Welcome, welcome.
Okay. All right, thank you.
As you folks can join us, we're just gonna give people time to come in, get settled. Now I can't see the chat. I can see the Q&A.
Okay.
I can't see the participants. So
If you had, should be a button down here at the bottom that says participants. You click that and it'll show.
okay, got it.
And the
Got
same
it.
thing for the chat too.
All right. All right. So we got a few folks in the room. Hopefully we'll get a few others. We'll just give them a little bit of time. And just to be mindful of folks' time, let's go ahead and get started, Tariq, if you don't mind. And what I'd like to do is just, you're kind of new to this audience. So if you don't mind, I'm going to ask you a few questions that are a bit personal.
Okay.
So the folks can get to know you, all right?
All right.
So here's one of the questions I love to ask people. First of all, we got to know where you're from. So where are you from?
I'm from Atlanta, Georgia.
All right. All
Born and raised.
right. Good. So what brings you to Baltimore?
I actually came to Baltimore. So I went to Morehouse College and Georgia Tech in Atlanta, and I did a study abroad after that. And when I came back, I was looking to get into the nonprofit sector. And so I came to Baltimore actually working with a nonprofit and doing commercial real estate and community development. So that's what brought me to Baltimore.
Okay, cool. So if your house was anything like mine growing up, before you can go out on Saturday morning, you had to do your house chores, right?
100%, yes.
So tell me this, what kind of music was playing in your house on Saturday morning before you can go out?
So on Saturday mornings, so my house was a Motown house. My dad was from Chicago, and you know, the Jacksons were big, Stevie Wonder, Temptations, anything Motown, Supremes, that was the soundtrack to my Saturday morning cleanup was Motown. So that's what was playing in my house. It's still playing in my house now when my children clean up. So yeah.
Nice. So I want to throw it out to the folks in the room. We don't have a whole lot of people here yet. We got about a dozen. So you folks in the room, I want to know from you. You can throw it in the chat. You know, what kind of music was playing in your house on Saturday morning when you were doing your chores growing up? As a teen, early teen, if your house is anything like ours, mine and Tariq's, you had that music playing, your parents had that music playing. I don't care where you're from, But what we want to know is what kind of music was playing in your house. I'll tell you right now, I'm from Philly. Music in my house was anything that came from the sound of Philadelphia. So we had OJs, we had, okay, I got some folks saying the chat is disabled. So let's put it in the Q&A, put it in the questions and answers. If you can't access the chat, put it in the questions and answers. Yeah, so like I was saying, for me, it was Philadelphia. Yeah, I grew up in Philly, the sound of Philadelphia. And it was the OJs, Teddy Pendergrass, Hal Melvin, and Blue Notes, you know, all the classics, all the classics. All right, so we got a Baltimore house music. Oh, I know y'all were getting a lot of work done with Baltimore house music playing. Your mom would try to work y'all if you had Baltimore house music playing. All right, we got some Marvin Gaye, we got some Patti LaBelle. Okay, that's Philly. Patty is Philly. We got Philly in the house. Okay.
I see somebody said NPR.
NPR. Oh, they were trying to get educated.
Yes.
NPR was trying to get educated while they get their work done. All right, that's cool. That's cool. All right, so we got a little bit of flavor of what was going on in your household. So let me see. Tell me, again, we're gonna let a few more people pile in. Tell me, what was your first car? What was the first car you drove?
So for me, I had a Mazda Protege. So I don't even know if they make Mazda Proteges anymore, but this was a small.
I remember that.
And I had a 95 Mazda Protege. And I was really proud of the car. Now the car said it was blue, but if you looked at it, it looked purple. It was I had worked during my college years, I worked at NASA as an engineering intern. I spent 4 summers working at NASA, and so I was able to save up money for my internships, and I was able to buy my car. So I was really, excited about that. But that was what I drove, a 95 Mazda Protege. And there's a stick shift. I don't even know if they make stick shifts anymore. Standard.
Yeah, I'm sure they're hard to get. They probably still make them, but they're probably hard to get these days. No, a 95, you're doing pretty good. You're doing pretty good with 95 Protege. That's a nice car.
Yeah, I mean, because I was in school, so it was only about when I got it, maybe 3 or 4 years old.
Okay.
And I was, I mean, now I don't know if you can buy cars for $5,000 anymore, but that's what I was able to buy.
No, but I mean, again, you started out pretty good. I mean, a lot of us, I was driving a bucket. I was driving something that barely get where I was trying to go. I was hoping and praying that it'd make it.
So I see somebody had a Buick Park Avenue.
Buick Park Avenue. Yeah, nice. Chevy Prism. Okay. Yeah, I remember Prism. I had a Prism. Nice, nice. So you working for NASA.
Yes.
So how do you get from NASA to where you are today?
So, my household growing up, my parents were into science fiction. So we had Star Trek and Star Wars. And I think for the moment I was young, we watched these science fiction movies. And I remember when Star Trek, they had the guy from Reading Rainbow, at least that's how.
Lamar Burton.
And he was the engineer in the next generation, Star Trek: The Next Generation. And so I was like, I'm going to be an engineer. And my uncle at the time, was he went to Long Beach State, but he was an engineer, and he was working on the Hubble Space Telescope. So I remember going to visit my grandmother, and we went to go visit him at Ford Aerospace, and we had a tour of the Hubble and the work they were doing. And I was sold on being an engineer. So that's what, I applied myself in school and got a scholarship to college, and then the scholarship was a NASA scholarship. So I was able to go to NASA research centers, the first one in Silicon Valley, and then the rest were in LA at the Jet Propulsion Laboratory, where they launched all the satellites, the Mars rover, all that stuff was going on while I was there. And so that's actually where I got introduced to patent law, actually. I was working at NASA JPL, and a gentleman by the name of Paul Ware, he's a Morehouse grad, But he was
Okay.
a patent
Okay.
attorney for JPL. And, he said, I heard there's some Morehouse, students here. He would always ask us to go by and speak with him. So I took him up on that, and I went to see him regularly, and he would always talk about patent law. And that was my introduction. I would love to say I got into it after that, but that was my introduction, but I didn't think about it again for like another, I don't know, 5 or 6 years. But
That's when the seed was planted, though.
yes. But he was saying it was a way to get into law and to do things outside of as an engineer, but get into the application of technology, not just developing technology. So that's how I got into it. So that started my journey to be into intellectual property.
Wow. Wow. So from NASA to patent law, now not necessarily law. So tell us the difference between being a patent agent and a patent attorney.
So interesting. Yeah. So I learned about this actually, so I left NASA, did some study abroad, ended up here in Baltimore, and got into patent law, working for the patent office. So as a patent
Okay.
office, you can be a patent examiner. So they teach you enough patent law to understand how to examine patents. So when someone comes up with the idea, they submit an application, you have to examine it and apply the law to examine the technology. So to do this, you have to learn the law to a level to pass the patent bar, in which is considered, makes you a patent agent.
Okay.
So someone that knows how to apply the patent law and the patent statutes before the patent office. Being a patent attorney is in addition to that. So a patent attorney would be one that would be someone who is actually an attorney in the courtroom. So a patent attorney has a JD, they go to law school, and they're able to practice law. So they're not just focused on necessarily patents. They can practice.
Patent is their specialty, but they're an attorney.
Right. So that's the difference. So I only focus on patents in terms of, I have authority, authorization, registration number, barred by the patent office to practice before the patent office. Once we go to court or we go outside of that, I am a citizen. I can't, I'm not able to practice law outside of that. So what we do as a patent agent, we also work as an intellectual property consultant. So we work with law firms, we work with startups, we work with companies. We help them to understand the intellectual property. But procedurally, when it comes to working before the government, we work as a patent agent and file patent applications, manage them, present them, get them approved internationally, domestically, and internationally. So there's not a big difference in terms of that. Those functions. It's just, I guess, the legal. So suing somebody, litigation, we don't do any of those things.
All right. So tell me, what would be the competitive advantage to a business owner or somebody who thinks they have IP to protect, if going to you rather than a patent attorney?
So there are a couple
or
of things.
You and your company, because I understand you guys do a lot of services.
Right. Yes. So I think the main thing, when you think of if you have something that needs to be patented, or you have an idea, or you have some type of intellectual property that you're thinking about protecting, one of the main things you want is, attorney is a very specific type of, I call it really like a transactional billable hour. You're going to be looking at a certain, they look at the legal matters in a certain way. In the reality is usually, law firms will actually hire us or hire a patent agent to do the work to actually, and part of our advantage, we also are patent insiders. So I've worked inside the patent office for 10 years. Our team, most of us are former patent examiners. So we know the procedures, the inner workings of how to get something through the patent office. Usually that's more efficient, more effective. And also because we're not necessarily interested in other areas of intellectual property law, we're very focused. So we get focused attention, we're specialized in a specific area as opposed to spread out across many different areas. So the advantages that people, tell us when they work with us is just we're very good at educating about the process, being very clear about what's happening, very efficient as far as moving through the patent process, going from application to getting, get one of these in the mail as a patent for one of my
Yes, sir.
clients. So we go through that process. And it doesn't mean that you won't need a patent attorney. I think so. There are areas of intellectual property, and maybe we can talk about this, but everything doesn't require a patent. Everything doesn't require. There are 5 different areas or categories of intellectual property. One of the things that we do is our approach isn't just say, okay, you need a patent, you need a trademark. We kind of take a step back and understand, what your goal is as a business. What are you trying to accomplish? And then also look at what's your intellectual property, where does intellectual property fit in that? And then we can kind of evaluate and create the best strategy. Because your strategy should include, eventually you're going to need, attorneys. If you're going to have something, you have $1 billion idea or a business that you hope to grow to that level, you're going to.
All right, so let's stop there. You said $1 billion idea.
Yes.
All right, so I'm wondering how many people in the room with us today think they have $1 billion idea? All right, should we just throw that to the Q&A, or do we want to put up a survey question?
So let me see if I have I'll put the survey questions up we have here. So you all have you'll see intellectual property quiz. You can, you'll see some of the questions here. And we'll put it to the side where you can kind of answer those and we can kind of discuss those.
Yeah, when you get a chance. So that's a few questions that we're throwing out here today. You guys can answer those, and we'll get to know you just like you guys are getting to know Tariq today. I see a lot of familiar names in the Q&A section, so I'm assuming that they all know me and know what I do at M&T Bank, Small Business Ambassador. I'm here to help you in any way that you need help. But we're here to introduce you to Tariq and why intellectual properties are so important. So you said $1 billion idea. So if you don't have $1 billion idea, I'm assuming that maybe you don't necessarily need a patent. How does that work?
So yeah, that's one. So one of the things that's important to understand is that, so the U.S. Patent Office is a division of the Department of Commerce. Commerce is like, deals with banking and the economy. So the idea for trademarks, for patents, or for covering intellectual property has a commercial interest. It's supposed to benefit a business or benefit the economy for the country. That's the thought of thinking behind intellectual property. And so you should have some kind of commercial vehicle, commercial interest. So it's not just an idea for an idea's sake. The idea of intellectual property is actually, the idea is an engine for commercial value that creates a vehicle for developing some type of commerce. So to get to the second point, yes, everything doesn't require a patent. So what we think, one of the things that services that we offer is just giving a simple analysis, understanding your business. Maybe it's not a business, maybe it's just an idea. Maybe it is a business. Maybe you have a startup or you have something more established, but depending on what you have, when you establish a business or you have something of value, you have a market, you have competitive advantage, you learn things that may be, present ideas that are advancing that. You want to protect those things. So if you have a new product and there's a way things have been done so long, and you're saying, well, I have an idea, I can make a better product. It doesn't always have to be something software or super technical. It can be something simple, but it's an improvement that simple improvement may open another market. It'd be $1 billion idea. It may be $1 million idea, but it's at that point it's worth evaluating, what do I have here? Is it something valuable? What type of intellectual property tool would help me best protect what I have? What would add value to what I have? What are the scenarios, what should I be doing to protect my idea? just knowing that risk and understanding, that's where we start before you just say, hey, I want to get a patent. Well, do I need a patent? Maybe there's some other things I can do to protect myself. Maybe I don't have a patent. Maybe I need to protect my brand name. You know, what do I need to do?
Well, along those lines, we got a question in not in the chat, but in the Q&A from Terry Wilkinson. She wants to know, what's the difference between copywriting your product versus getting a patent?
Definitely. So that reminds us, one of the questions in the quiz is, and I gave a really good example. If you go to, we have a website, patentinsider.co. We have a blog, Patent Insider Secrets, where we give examples of really stories that kind of illustrate these differences. So there are, I would say, 5 different categories of intellectual property protection. So intellectual property are ideas, thoughts that you have in your mind. This thought property. So just like we talked about the car is, real property, or a house, or something that you can hold on to, or even your clothes or your glasses, that's something. But intellectual property exists in your head. And so there are different types of ideas, and there are different ways to protect them. So one of the legal tools of protecting an idea is copyright. A copyright protects authorship. So we think about authorship. We talked about this, music. We talked about the Philly sound. So Patti LaBelle or the OJs, or you talk about, Motown, Stevie Wonder. So these are all artists that create music, and they write these songs, they arrange the music, and so they copyright that. That means they say that this composition, I'm the author of it. And then when they register their copyright, we hear about it, it's called publishing or protecting your music catalog, or owning your masters. All this is saying owning that intellectual property that goes into your idea. So copywriting is authorship, and that's valuable. You've heard, I'm sure you've heard about when someone, now rappers will sample one of these songs from this time period and not prove it. An example that I to give people was like, there's a song, popular song by Puff Daddy or P. Diddy. He did a song, Missing You, about a Notorious B.I.G., and that sampled Sting. He didn't get permission. So Sting gets 100% of the value of that song. So it's something like breaks down like $2,000 a day, because he didn't sample, he didn't get authorization. So when you own your idea and you have the proper legal tools in place, then you can protect how it's used. Now you said versus, what's the difference between that versus getting a patent?
You gotta go after that person, right? First of all, you gotta find out about it.
Yes.
And then you have to sue that person for whatever you determine the value to be.
Yes, and there's different processes. Like for music, there's clearance, sample clearance. There are processes in place that the production company or the music company will take to limit their exposure. And so there's a process.
Okay.
And so that's how a lot of times artists find out, because they're like, oh, someone's trying to clear this sample. They'll find out about it. That's brought to their attention. But that doesn't happen in every case. Like for a patent, you have to actually seek out and kind of monitor what's being patented, and to see if somebody's infringing. So you have to kind of snoop.
Yeah, that's where I was going, because you could spend thousands of dollars on a patent, and somebody across the country could be doing the same thing, and you would never know about it.
Right.
So not only is there cost incurred with filing it for the patent itself, but then protecting that patent. Right, you have to be on the look for people who are infringing on your patent, which could also cost you money. So these are the things that you have to include in as you assess whether it's worth it for you to have a patent on your product or not. So Terry, I hope that answers your question on copywriting. That's your we got a pretty good understanding what copywriting is, and we'll get into. So that's one. What are the other 4 different types of IP protection?
So then you have trademark protection, which is about protecting your brand name. And this is, if you think about, people think about brand names like, handbags, you have your Gucci, your Prada, or think about it with shoes, you have Nike, you have Jordan shoes. So these logos or images or brands, you can protect the name of it. You can protect the slogan, like we think Nike, just do it. We think the brand itself, or the logo or the image, or just the word. And so protecting these in certain classifications, certain markets where they're going to be used. So like Nike is protection, they have trademark protection for that word Nike and for their slogan and logo as it relates to athletic shoes, as it relates to clothing. They don't necessarily have that when it comes to food, or let's say some other service that's just not related to their product. So someone could technically use the word Nike in an unrelated market that's not protected. A good example of this, like you have Delta Airlines, you have Delta water faucets. If you go to Home Depot or Lowe's or a hardware store, you buy a faucet. It's a Delta faucet that has a registered trademark, but it's not the same, as Delta Airlines. There's no confusion because they're two different markets. So that's brand protection. This can also goes for social media handles. It can go for your website, can go for the name of your company. A lot of different things that relate to brand protection. So that's copyrights and trademarks. Patents are inventions. So when we talk about inventions, we're talking about either the how something is used. So we're talking about, it can be a composition of matter. It can be an article of manufacture. So this can be something that you created, a new way of making, a product. It can be a method. It can be a system. It can be, it could be a new pharmaceutical product, a new drug, a new chemical that you created in a laboratory, as well as something physically tangible. And in some instances, it can be a business method or a novel business method or some type of software. Now, those are business methods and software. Those are harder to get because you have to have a tangible, something has to be tangible to get a patent, but that's the idea. It's actual invention. You added something of value, either, have an improvement on a product or you created a brand new product. So both of those are eligible for patents.
So I want to touch on that a bit because people, everybody has some intellectual property in my mind, right? I don't care what you're doing. If you're a salon owner, the way you might have a certain way of curling hair or pressing hair or doing whatever you do with hair, right? That still is intellectual property. Now, whether or not you want to patent that, you have to, again, do some of the things that you're talking about today. You have to do that assessment and see if it's worth it. But it does have value, and people need to take note of and document those things that have value. If you decide to sell that salon, right, that's a separate entity. The salon is one thing, your book of business is another thing, and then the special way that you do things is a whole nother entity that has value. Correct?
Correct. So I like to think
so
of
people
intellectual property
need to
as
understand.
assets.
Yeah.
Yes. In fact, we call it intellect. We talked today of 5 areas of IP, but the way that we think about them, there are 3 different categories of how you use it. The first one is intellectual property asset development. All of these things we're talking about for your business, whether you have copyrights, trademarks, patents, or the other ones that we'll discuss, that's all developing your intellectual property asset portfolio. That's you're developing your portfolio of intellectual property assets. Those have separate value apart from your company, apart from, like you sell the business, apart from your book of business, all that's separate and apart from intellectual property. If you do, if you get, a financial statement, you'll have intangible assets and patents, trademarks, intellectual property is part of that assessment. The second area, once you have that portfolio of assets, and the whole idea, you're building a portfolio of assets to protect yourself. They call this like building your castle, building your fortress. You're fortifying your ideas, protecting yourself. Because business, they liken this, business is warfare. So you want to build your fortress, build a fort, build a castle, build a moat, build it out, and that's what these tools do. The second thing is enforcement and defense. That's the fight. If someone wants to steal your ideas, you have to have a way to enforce your IP rights and defend. This is usually litigation. And sometimes it's not litigation, but for the most part, that's a strategy, that's a separate area. And then the third area is commercialization. You can commercialize your IP. Let's say you're running your business, but you can also look to other businesses that may benefit from your IP and license your idea to them and create revenue. An example I like to use, play the game Angry Birds, and they have a huge business based on selling that game and using that game and advertisements, but they make, hundreds of millions of dollars off of toys. They don't make any toys, but they license their IP to toy companies. Video games, movies, they're not in the film business, but they license it to the studios and they make money. That movie generated like $500 million. So cartoons, all these things, if you own the intellectual property, you can license those rights and generate revenue. That's not even the biggest bulk of their revenue, but they're able to make money just by licensing those ideas to people that do that or in that business. And so the Halloween costumes, all the different things that are made off of an Angry Bird and those characters, they're not making costumes, they're not making movies, they're not making cartoons, but they're making money off of that because they own the IP and they license it to the companies that do those.
And they protected it first, and then they licensed it.
Correct.
Right. Great. So we got another question, right? So we got Latoya Renee. She's an herbalist, and she said she has an online apothecary and she manufactures her own products. So would she be able to patent her recipes?
So this is a good question. This actually takes us to the next part of, we said there are 5, so this is number 4. So usually recipes aren't patented. I'll give you a good example. So like we have the Coca-Cola recipe, right? It's a formula. It's not patented because what a patent is public. So
full disclosure.
It works. You give full disclosure. You give it to the public. The government says, okay, thank you for doing that. Because you're doing that, you're advancing the commerce of our country. We're going to allow you to own this exclusively or have license to it as yours for 20 years. Then it becomes public. So, Coca-Cola doesn't want to do that. So Coca-Cola said, This is mine. I'm going to make it a secret. It's called a trade secret. Another thing we think of, KFC's 11 herbs and spices. We know there are 11 herbs and spices I can buy at the grocery store.
We don't know exactly what they are.
I don't know what they are. I don't know the order that you put it in. When it's a secret.
I know there's some salt in there somewhere.
Right. There's definitely salt and some pepper, and we could probably say some oregano. Whatever. It's just something in there, right? We don't know what it is. And so we know it exists, but we're not given the exact amount. And so this type of strategy is a IP protection strategy that is, you use contracts, you use other ways of managing the IP so that nobody knows it. I think when I went to the World of Coca-Cola in Atlanta, they say that nobody has the recipe. They're different scientists that have parts of it, and they have some of it is, they have extra things that aren't part of it, so they don't know, and they're never in the same place together.
They got like an okie doke out there,
right? People
think might be it, right?
Right, and so, but they're able to bring those parts together, and that's so. A trade secret oftentimes is a better way, a better approach for things that, like sometimes you have a business, you have a specific business practice or methods that you use. Maybe it's a training method. Maybe it's something that's proprietary in terms of how you apply strategy. Maybe it's your consulting secret sauce. You don't want to necessarily patent that, but you do want to, you can still create IP around it. You can make it a trade secret, and you could like franchise and license that out, but you have to, create some type of vehicle to control it, have some way that you control ownership. So it's a different type of vehicle, but it still is intellectual property. Does that make sense?
And correct me if I'm wrong, but I think one of the tricks to that is that you really have to keep it secret, right? You can't have a trade secret and have it posted up in your office, right? Then it's not a secret anymore. And then, you really can't protect that if you're giving it away. So if you're going to have a trade secret, you have to go through certain lengths. I mean, if you were to try to sue somebody for, hey, you took my trade secret, and there was an investigation done, they see you got it hanging on your wall, you're going to lose that fight. because you're not doing what you can to keep it a secret, like Coca-Cola, right? Where nobody knows. So yeah, you really have to make secrets secrets. All
Yeah.
right, so thank you for that. We got one more one more question. We got a few questions. We're trying to get to all of them. So one from Lynn Platter says she's creating doll characters from a book, from I think it's her book. And is that something that she should patent or trademark?
So this is, I would say it depends. We'll have to know more about the specific situation. So like, if we look at, like, I'm just thinking of, like, think of comic book characters, right? You have, they're making these movies, Marvel and DC movies, the Black Panther,
Right,
the Avengers, all these things are based on
They got a lot
characters.
of money off of them.
And so that, the Marvel Studios is, a division of Marvel, which is the comic company that created those characters. And so part of the intellectual property, this is, I would say, we're going to authorship here. So it's copyrights. That copyright is owned by Marvel, but it's also the originating artist is, Stan Lee or some of the other people that have originated these characters. And so you'll see settlement agreements or some type of agreement with the estate, because copyrights are a lifetime of the author plus 70 years. So this is how you see, like, states like Marvin Gaye's estate settling with Robin Thicke on some,
Right.
copyright infringement. So copywriting is one way to protect your authorship of you creating a character or dolls from a book, if it's your book. So that's one way. If you are, like, I would say if it's a brand, you're not necessarily protected. So that's copyright protects the authorship and maybe the artistry of that. And I'm thinking of, like, these dolls. I remember they're called, like, Bratz dolls, and they have a certain
Yeah,
book.
yeah.
So that was a book or a cartoon, and then that branding of that is a trademark, so that it becomes marketed as a product, and that trademark is something that protects the marketing, the brand name, but that's not the doll. The doll is copywritten. If the doll is unique in the sense that there's no other doll in the market like it, you could explore a design patent, which is saying that the way this doll is, the either not the material, but the way that it looks is unique. This is a unique product. It looks different. Nothing else looks like it. I want to protect how it looks. And this, even with like Nike's, their shoes, they have different shoes. They have a design pattern on the Air Force One, the way that looks, certain shoe, you can't make another shoe that looks like that without infringing on their patent. So, but it really depends on the specific type of product and company, which makes sense. In some cases, you may have multiple IP tools to protect yourself. You may have a patent, you may have a trademark, you may have copyrights, you may have some trade secret elements, depending on how complex your intellectual property is.
So if it came from a book, in Lynn's case, if it came from a book, that book needs to be protected first.
Yes, that needs to be copyrighted.
And then the product that comes out of that book may or may not need to be patented.
Yes.
Depending on uniqueness, it sounds like.
Yes, correct.
Okay. All right. Well, Lynn can follow up with you later if she wants to get some details. Now we got some long questions in here. Okay, so Lynn says she did copyright the books. So
Okay,
she's going to talk to you.
Yeah, so we are talking a little bit more specifically, but I think if you copyrighted the books, then you have a level of protection. To the extent with the characters, it really depends on what you're doing with the characters. And the copyright protection may extend to those characters, just depending on how you're using them in the marketplace, whether a trademark or a patent would be appropriate.
Okay. So Terry Wilkinson has a question. It's a long question. I don't know, Terry, I don't know if can she come off mute and ask her question? Because it's a long one.
Let me see how to do that. Okay.
If not, I'll read it. I mean, maybe she doesn't want to come off mute. Terry, do you want to come off mute and ask your question, or you want me to read it?
Oh, sorry. Can you guys hear me?
Yes.
Yeah, we can hear you.
Okay.
Morning.
I'm sorry. Yeah, it is a little long. So my company offers behavioral health consulting services. So I frequently create tools and strategies for companies, like for like program development and things like that. I recently got a lawyer for like my corporate counsel, but I'm finding that people are already using my work, like in the behavioral health industry. And so she's advised me not to engage in consulting in that manner until I can protect my intellectual property. And so I'm trying to see is like, what is the quickest way? Because I looked at the process and it takes some time to copyright. But what is the quickest way that I can be able to protect my property by like either copywriting? Can I use an ebook? Like, what can I do to like, I don't know, because like I'm using like Excel sheets, I'm producing like manuals and things like that, and then people are actually implementing these programs.
Wow. Thank you.
This is a common, I would say definitely a common situation. And it's not just for your type of business. I mean, many businesses, the focus of the business is to get to, I don't say get to the money, but you want to, solve your clients' problems, generate revenue. And in the midst of that, intellectual property is more like an afterthought. You are creating intellectual property. One big thing that you need to do, are any of these things published outside of what you're giving your clients?
They are not published because previously I started this business in 2020 and I didn't know any better. And so I was working under someone who had more experience. And so now she's misrepresenting herself in terms of like using my quality tools. And, in the healthcare industry, value-based care is a big thing. And so having outcomes and metrics and being able to track these things, she's already implemented, but I have new programs that I've developed. And so I'm trying to not make the mistake of giving it to people because I am consulting, but these ideas that I come up with are starting to be, I can give someone the idea, but I need a way of protecting the idea before I give it to them for implementation.
Right.
So this would definitely be a more complex solution, but I will say copywriting any paperwork that you produce, and this is even if it's like a white paper, internal document, copywriting those things is the first thing because you're proving authorship. You're documenting with the government saying, this is my document. This is originated from me. I'm the author. So that assigns ownership and authorship. It proves it. The other types of things that like if you have you create a brand around it. So creating a brand around your specific type of consulting service beyond your name. Let's say this is you develop a mechanism or a name. Let's say this is the Terry Wilkinson value method, or develop a unique name. Then you can trademark that name. Then it's you're coining the phrase, so to speak. And so that's another way of protection. That's a trademark protection. And then more specifically, this would be considered a business method. A business method is a type of patent. It's tough to get, but it's, we'd have to evaluate the efficacy of a business method patent. Is it worth it to you, depending on what what level of business the value you're trying to protect. And then you could potentially, get a business method patent. And then that would be something you could license out. These people want to use it, as an option. But it would be that layer approach. You'd have to kind of look at it those different ways and evaluate what makes the most sense to do right now versus later. But that, yes, you probably would need to look at multiple intellectual property tools to protect yourself.
Okay.
So it sounds like she's looking for something immediate. Like what's the best thing for her to do right now to start? What about the documents that she already has? Can she somehow, does she take a picture of it? Does she, like today, to see how could she prove that she had this stuff since 2020?
The best way to do that would be copywriting, to get it copywritten right now. And that's something, you go to copyright.gov, you can upload it. I don't know what the fee is for copywriting right now. So it's less than $100 to copyright something, but you can upload, like if you have an ebook, you can upload those things and upload those documents and just, prove that you're the author. You can tell them the date, in the application when you
Okay.
first started using it. And that would be the simplest way. It's not if you haven't done it before, it can be a convoluted process, but that's the best, the quickest thing. Everything else is going to take time. You're talking about years before anything would happen.
What about a
Wow.
non-disclosure agreement?
So that gets into the, I will talk about that, the next thing,
Okay.
the fifth area of IP. Yes, your agreements, your policies with your clients, having an arrangement where you and this is, I call it the fifth area, you're dealing with your policies and procedures, your internal and external policies. You're going to be dealing with anyone that you deal with internally that works for you, who owns the IP, what their relationship is with intellectual property, what they can and cannot disclose. And the same thing with anyone that you work with externally. It can be your client, it can be a contractor, their third party that works with you. If they have access to know-how or certain intellectual property, what their limits are. So you have to define that before you engage. So that's clearly part of the engagement process, and that and identify, and you want to use the best practices. So that is, and these things take time. And so I think like one thing you can do quickly is copyright, and the second thing will be similarly in terms of time would be to evaluate. If you have corporate counsel, evaluate what their recommendation is for your policies. But that's also something that we go through all 5 of these areas. We establish IP strategies. It's one of the things we do for businesses, especially that have cases that aren't cut and dry. They really do an assessment and go through these 5 areas and look at what the best strategy is for you. Because it doesn't pay just to say, okay, I have an attorney or I have someone here, but you have no idea what to do or what makes sense, what mitigates your risk. You don't even know what your IP exposure is. And that, you asked earlier, James, like what the value is of a patent consultant or patent agent. We're not looking at this as necessarily billable hours like an attorney. The way that we approach the problem is more like, my background as an engineer, more as a system solutions model. We're looking at how do we apply, give you a system, apply our system to your problem, and then create a solution, a plan, a strategy for you to implement that allows you to get the maximum result and value.
Thank you
Great.
so much. It's
You're
been very
welcome.
helpful.
You're welcome.
All right, so our next question comes from, you'll see it in the Q&A as Matthew Tompkins. I know him as Jason.
Okay.
So, Jason, do you want to come off mute, or do you want me to read your question? Because it's got a couple parts to it, like Terry's.
Okay, I'll bring
Hello, can you hear me?
Good morning, yes.
Good morning. So my question is so if you file for a patent for some type of manufacturing process or some type of sequence of manufacturing process that perhaps increases your speed at which you produce products, how would you protect that and know if other people find out about it and then they start using it? How would you really protect yourself in that type of situation?
Okay, let me just make sure that I understand. So you're saying you have an improved method of manufacturing.
Well, I have ideas about how to increase productivity in manufacturing and how to kind of put out products quicker, but other manufacturers might find out about it, or they could use it, and without it being public. How would you really protect that? So for instance, how Amazon has I think they just filed patents for they manufacture as you click the button, and so they filed patents so like other people cannot do that same process, but it increases their productivity. So I'm wondering, had they not posted that in the media, no one would know. So, so how do you protect yourself against those instances?
So in this particular case, so this is I would say this is kind of counterintuitive, but it's the way the process works. So the very nature of IP is that it's a thought in your head. You can't protect it without telling somebody what it is. You have to, I mean, unless you have a trade secret,
Right.
you have to tell someone what it is, and there's a very specific way you have to do it. So for instance, in a patent, you're filing a patent application, and there are ways you can redact some things. You can file a provisional patent application that's not published, and you have patent pending protection, but you're not necessarily disclosing it. You also have you can say, I don't want this published until the patent is granted. So for the entire time it's pending, which could be 2 to 3 years or more, there's no public document until it's actually granted. Once it's granted, it becomes public domain. And so those are strategies that are used to kind of protect things while also going through the public process of getting patent protection. And now all this is under the category, or I said the 3 categories. The one is IP, or intellectual property asset development. You're fortifying your idea, you're building your protections around it. During that stage, there's going to be, some strategy, some public things, some private things, some hidden things, but eventually that's going to become public. Now, the second phase is, which is gets to your question, how do you protect yourself? Well, you first have to develop the asset. You have to disclose in some kind of form or fashion in a way that's going to protect you. The second thing is, how do you enforce or defend? And so there are different strategies in place. So one way, you can get litigation insurance, where you can say, okay, I filed this patent, I want to be insured against, because it can cost, let's say, $3 to $4 million on average if you have a really big case to defend, you can end up spending that kind of money. So you can insure and pay a fraction of that and still be protected. But you need to have a strategy. One is you need to, awareness is one of the first things. I can't enforce it if you're not aware of it. So if you ever heard of cease and desist letters, like you have to put somebody on notice that they're infringing, or they may be infringing before, and from that point forward, you can start collecting damages or calculating damages. If you're not making it publicly known that you have these rights, and that's why, if Amazon puts it in a press release and you're infringing it, you can't say I didn't know, because now I've told you. So that's part of the strategy. That's why you'll see this happen. Like you said, if they didn't put that out, nobody would know it. They want you to know, because if they take a reasonable course of action to make it public information, to put you on notice, then now they can say, well, from this date forward, we did this press release. Anybody that's infringing, we're going to start calculating from our press release. And that way we notify the public, and we also notify, they may also send mailers or send that article to their competitors just to let them know. And so it's a strategy that's involved, and you'll work with litigation partners that deal specifically with this area to help you maximize your ability to enforce and defend yourself. But it's a very specific legal strategy. And what we work at I'd say a 30,000 foot level looking at all the strategy, but focus on that first one, building your fortress. These other ones would have partners, and you have to work specifically in these areas to find out the best strategy for your particular patent or product. Does that make sense?
Yeah, good answer. Thank you very much.
So you know what, Tariq, what I want to throw in here is, again, go back to one of our first questions, right? Is this $1 billion idea? Right. So Jason, I want to ask you, right, this new process, is it $1 billion idea? If somebody were to find out how you're doing this and they copied it, right, are they going to make $1 billion off of it? Are they going to keep you from making $1 billion off of it? Is the idea big enough that it's worth your time of spending these, all the time and money that Tariq's talking about to protect it?
So yeah, and I think that talking from a small business perspective, if another company that did have the capital to implement like my process or idea quicker, it could definitely be more than $1 billion idea, especially if they have the manpower to fill it quicker.
Okay, well, that's part of the assessment that Tariq's talking about. You got to think about, basically, do you just keep it to yourself, or possibly not implement it because you think somebody might steal it, and now they don't have it and you don't have it, right? Or do you just go ahead and run your business and implement your process and make as much money as you can, and not worry about somebody else stealing it, and just do the best you can for you. So that's part of the evaluation that you have to take into consideration.
Okay, thank you.
You're welcome.
Thank you.
Thank you. And we may get to that, James. We do have, we'll put it maybe here in the chat, links to schedule basically a free consultation to try to see where you are. It starts answering some of these questions. And this is something that, while I'm sure you can get consultations from different types of IP professionals. Our approach, we've successfully used it from working with startups, working with small business owners, some big government contractors, now started with enterprise level companies. This system works. Thinking about things, having a systemic way to approach your idea and evaluating, the IP risk and value, and having a way to look at these different categories. It's honestly something that's not really done. And I can tell you some stories about, big companies that are, highly valued, lots of investment, that didn't do these things. And, had some pretty big, one example, if you allow me, Jim, is, who's heard of Clubhouse? Anybody heard of Clubhouse?
Definitely.
Yeah. So
hottest thing about 12 months ago.
Right. So Clubhouse came out with this idea of, having audio only meetings or a social media app that was based on audio. And nice idea. What Clubhouse didn't do, first, they didn't protect the name Clubhouse. It came out after they did their press release, about how much money, how many hundreds of millions they'd raised. They were sued promptly by a company called the Clubhouse, which was a social media app for sports agents and people that worked in sports. So it's really based on, baseball players have a locker room called a clubhouse. So these were baseball professionals that worked, they were agents, they were trainers, there were others that worked in the field, and it was a app they used to communicate jobs. So they sued. They had a trademark for their app. Small app. It wasn't a huge app like Clubhouse, but a company that was valued at $4 billion with a B, that raised money from the likes of Microsoft, Bill Gates, all these other people, they didn't file a trademark. Trademark was cost $4 billion. I mean, let's say for them, okay, maybe it costs $5,000. You're telling me you can be valued at $4 billion, but you don't do a trademark search and you name your company? They also haven't filed any patents. So if you notice, Twitter has an audio app or audio feature called Spaces. Clubhouse on Twitter. You don't have a patent, so you can't do anything about it. LinkedIn, I just got an email from LinkedIn yesterday that's saying they're going to have LinkedIn audio. Clubhouse on LinkedIn. Clubhouse doesn't have a patent. So if you don't do this evaluation, how fast do you think that $4 billion is going to go to zero because you didn't protect what you offer to the market, and now they're copycats and you have no way of enforcing it? Now, this would be a different conversation if they had a patent and they're licensing their technology to Twitter, they're licensing the technology to LinkedIn, but there's nothing that I've seen that shows that's what's happening. Now, that's possible they could be doing that. It'd be unlikely because usually the way you do that is you get a patent, you protect yourself, and then you. So just, these aren't just for small business owners. This is for everyone. And big companies don't do this assessment all the time. And end up having to pay settlement. I'm sure the settlement cost that Clubhouse paid to the other app Clubhouse was much more than the cost of getting a trademark search and filing a trademark.
A lot more, a lot more. All right, so we got a question from Shahida. In order to protect one's business name usage by others, should this be trademarked? Can the business name be trademarked and the logo of the same business be trademarked separately?
Okay, so let's see. In order to protect one's business,
So should the business name be trademarked to keep people from using it?
I'm make sure I understand what's in order to protect one's business name. Should this be trademarked? Can the business name be trademarked in the logo? Okay, I think I understand the question. So there are different types of trademarks. So like we said, a trademark, you have a name, you can have a logo, you can have a slogan. So, a business can have all of these things. So a lot of times people say, I don't need a trademark. I got my trade name down at the, SDAT I filed, and I have my trade name. And that's not a trademark. That means that you register the name of your business with the state, and it can be, here in Maryland, it's Department of Assessments and Taxation. But in other places, it's through the Secretary of State. You file, you register your business name. That's not a trademark. That just means that in the state that you're operating, you've registered yourself as a business in that state. It doesn't offer you, it means that in your state, no one can use that same name for a business, but it doesn't mean that online somebody can't use that name. Doesn't mean that somebody in another state can't use that name. And
I've
so,
seen people who registered in their county, like they'll register with Howard County and think they're protected.
right. Well, yeah. So you're protected in the county, but that's not. So a trademark is federal, and so this is also something we didn't really talk about. But there's jurisdiction. So intellectual property, just like that example of county or city or state, the same thing is true with trademark. So a federal trademark in the U.S., a U.S. trademark with the U.S. Patent and Trademark Office, is for the U.S. You have to. It doesn't protect you internationally. Internationally, if you're doing business internationally, you have to use what's called get a Madrid Protocol trademark, which they'll take your U.S. trademark. Madrid Protocol is a treaty or protocol that was signed by a number of countries in Madrid, Spain, and so if they're signed onto that, you can extend your trademark protection internationally. There's fees involved and things like that. But yeah, so protecting your business name on that level, if you're doing any business outside of your state or outside of your county, it has to be done on a federal level. It has to be trademarked. If the same thing is true, if you have a logo that's unique, and you're doing business. Right now, anyone that's doing business online, you have to get a federal mark. I mean, online, anyone that has access to the internet can purchase your goods and services. So if you want to protect that, it's not enough just to put the word TM. They call that common law trademark.
That doesn't work. You just write TM on there.
So it does have a value. The value is saying, so if I write TM, you're saying that I intend for this to be a trademark for my business, but it has no protective value.
All right.
So like I can, right click on your image and then use it on whatever I want to use it, with that TM or not. Now, if I have an R with a circle, that means I've registered, like with my business, Patent Insider, the name Patent Insider is trademarked. We own that mark. Now the logo is not. So I have a TM on my logo, but the word is, so there are different types of trademarks. A word mark is the strongest mark, because anytime I use these words, whether it's associated with a logo or whether it's associated with anything in my market, it's protected. So nobody can, like the word Patent Insider, some other company can't use the word Patent Insider to describe anyone in their business. I have a right to sue them if they did that. Now my logo incorporates the word, so necessarily have to trademark that because the words are in there. So,
But the
but
word's covered. Yeah.
yeah, the words covered. But I could also trademark the logo. And if I had a slogan, like if I have this thing, patent your ideas, I don't know if I would want that to be our slogan, but if that was our slogan, right, I would say, I'm going to patent that too. I mean, trademark that. I would trademark that as well. So you have to ask yourself where, and this is really big. If you have a business name, like sometimes your business name and you're online, you're on Twitter or you're on Instagram, or you have a social media name that is your business name. You can have hundreds of thousands of followers. If you haven't trademarked your business name, someone else can trademark that name for something else, and they can force you off of your platform. And that's how you generate your business. And that's happened. I had people come to me, they stole my hashtag. They took my hashtag, or they took I had to change my name. So, and you'll see that sometimes. You'll see big followings and they'll change their name. And like, what happened? They changed their name, maybe because somebody sent them a cease and desist letter because they have a trademark and they're
So
building.
they had it first. Somebody else had it first.
Right.
Or somebody stole it.
Right. And you can, so sometimes putting that TM, I've seen protracted litigation where you're proving in court that I used this first, and then you file the application. So I've had one where an employee worked for someone and they filed a trademark themselves, started their own business. And then the parent company, the original person that hired them, filed and then said, well, no, we had it first. And they had a dispute, but it escalated. It had to spend a lot of money, had to get attorneys involved, go back and forth in the patent office, litigating out, improving, and they won. But had they just filed when you start your business, you draft your documents, when you file your form with the Department of State, had you just done a trademark then?
Right.
Open and shut.
So Jahida, did that answer your question?
Okay. I think so.
I hope that answered Shahida's question. And then Lynn says she missed the fifth type of IP. It had something to do with non-disclosure agreement.
Right. So I call it policies. So internal and external policies. So the 5 copyrights, trademarks, patents, trade secrets, and then your internal and external policies. How do you, when you engage in business with somebody that's an employee or works for you as a board member, has access to your intellectual property, defining those policies. And some of these things that you think of like non-compete or non-disclosure agreements, non-compete agreements, clauses, these are some of the best practices, and they're different by state, different by sector of business, that what's allowed in different states. And then, you work with contractors, you work with third parties. A lot of times this happens with software, like you hire somebody to build your app or write your software, write your code, but it's your idea, but they're implementing it. Do they own the IP? If you don't define that, you can get a case where you're filing a patent for some technology. I've had cases where someone has developed something and they've designed it. They hired an engineer to develop it. They filed the patent. When they're getting the patent, the engineer is suing them, saying, I want such and such money, I want patent credit, I want to be credited as an inventor. They didn't work it out on the front end. And so now whether they're off to make money now on their product, that's jeopardized because this person is causing a lot of problems. They're also petitioning to the patent office to be added as an inventor. So anybody that's an inventor can sell the rights to your idea. So they can sell their rights. They can say, we were both inventors. Okay, I sell my rights to this company. You don't have anything to do with that. You don't benefit from it if you're the other inventor, if you're the one that actually came up with it. So defining this ownership is crucial. And again, this goes back to the example, like another example I'll give is, and it's how, so that if we all know that if you're in Maryland or the DC area, you know that the Washington team is now the Washington Commanders. Well, this changing of names has happened a lot. And one it happened with the Cleveland. So Cleveland, baseball team formerly known as the Cleveland Indians, is now known as the Cleveland Guardians. So they did this, I want to say about $50 million rebranding campaign, huge Cleveland Guardian, and they went to file the trademark, and they couldn't file the trademark. Why? Because there's a Cleveland Guardians roller derby team. Same imagery, same, and I guess that the word, something to do with the culture or the history of Cleveland, that the word guardian has significance. The imagery that's associated with it is not just first for the baseball team, but something, part of their culture. And so I'm sure that's coming soon, a settlement or shared IP agreement. But can you imagine being a multi-million-dollar or maybe $1 billion plus baseball team having over 86 years?
They did a $50 million rebrand.
And didn't do a trademark search.
And nobody did a search first. Nobody did an internet search first.
No. You could have Googled this internet search, just the internet search, you would have found the website, Cleveland Guardian. So that's awesome. They couldn't get the website. There was a lot of things they didn't take into consideration. And so these are very common.
So these little folks shouldn't feel bad when they don't have their stuff protected, when these $50 million companies aren't protecting their IP either.
So that's how we develop our system. We study these situations and we say, okay, how do we prevent this? How do we have a system that you can come in and you can ensure that you're going through the proper steps and being protected?
And again, I'm assuming most attorneys aren't going to do that, right? Most attorneys are just going to do whatever you tell them to do. If you tell them, here, file this patent, they'll file that patent.
That's it.
They're not going to sit down with you and say, well, wait a minute, let's look and see if this is the best path for you or just the best tool for you. So
that's true. The way that I learned this approach, and when I first kind of caught into this approach, early on when we took the patent bar, we started working, contracting with law firms and patent law firms. And I worked on a big, I can't talk about which company, but we worked with some large companies, big four, tech companies. And what I found is that when you work with these companies, you get this out the gate. This is part of what you get. So it's a team, I'm on a team there. There's internal, so there's the IP counsel for the big company. They have a team of attorneys. There's the firm they've hired, which might be 5 or 6 attorneys. Then they're bringing in contractors and others, consultants. And so you would have 20 people there, and all we're doing is going over strategy.
Wow.
Make sure that the strategy, and that's all, and the retainers are, $250,000, but this is, now when I worked with firms that work with startups and small businesses, the first thing we do is just the transaction. It's how much it costs, and we provide the service. Strategy was minimal. And it's more so left up to the business owner to kind of figure it out. And so what I said there's really this is what's happening on the highest level. And I mean, I don't want to say it was redundant, but some of the things like we'd meet to determine the number of claims that we're going to write. And we go back and forth. You have several meetings over and over again for something as minute as we'll do one strategy, draft something and then come back and go back to the way it was, a month ago. But they're putting that much investment and they're moving quickly. We weren't taking 6 months. They're filing. When I was working with one company, I only worked on one of the projects, but they were doing something like 50 patents a year. That's just that one division. I don't know how much the company was doing, but that was the focus. So, what we strive to provide is something like that high level strategy that you would get if your company was a 8-figure, 9-figure company that you're going to get. And you will still need to get that, as you go through these different phases of IP, whether you're fortifying, whether you're going enforcement and defense, you're commercializing. That'll still be a part of it. But we want to bring that to the small business owner, to the startup, to the burgeoning enterprise level company, to have a solid foundation of IP when they start. And that makes
so Tariq, a few months ago, I referred a young lady to you.
Yes.
who was at a university. We wouldn't keep all the names out of it. She was at a
Yes.
university and she had developed some IP and she was running into some issues.
Yes.
So can you share with us how that works when you're either a student with a university or perhaps you're an employee and you develop a new way or a new product? You know, how does that work?
Oh, well, that's yeah, that's a great question, James. So, you know, when you go to university and you apply, there's this question or this statement that says you acknowledge that any intellectual property that you develop while at the university or using the university's computers or tools or systems is property of the university, and you assign your rights to intellectual property by signing the terms and conditions or signing this application. It's a box that's
A
checked.
lot of employers do the same thing,
Yes.
correct?
Correct. And so we don't think about it, let's do it. And you know, when
You
you're
want that job, right?
right, you get a good job, it's an offer, or you're going to do your research. One of the things that's not discussed is what happens when you actually do create something. So especially when you're in graduate school at a university, you're doing research, you're working with professors, your whole goal is to create something new or further research. What happens when you further research that actually is commercially viable? It's not just a research project and it's going to go in a book and collect dust at the library. This is something that's actually making money and has potential. What if you're, and I'm trying to, you know, say things without going into, you know, our particular situation we talked about, but if you're somebody that says, okay, you're not only a research, you know, graduate student, but you're going to go get it. You're going to go call companies. You're going to try to bring in partners to fund the research. You're building relationships. Let's say you bring in a company, you're doing this work. It's bringing money to the university. You're getting a fast track to your master's or PhD. And you're assuming, the assumption is that since I came up with this, when I graduate, I can leave and I can make money with this idea. I can take this company that I brought in, is giving money to the university, they can hire me and I can continue to make money with this and I can, you know, really push this forward. And that unfortunately couldn't be further from the truth. What happens is when you graduate, all your ideas belong to the university. That relationship belongs to the university. Your relationship with the university is severed. Unless you are a postdoc or you have some kind of other arrangement, which any funds that come in go to the university and they agree to pay you. They also can say, well,
Or not, right?
yeah, we don't have to pay you. And they can stop you from working with someone else to get funds. So this is something that is critical. Now there's another story I like to tell, that if you understand the value of intellectual property, you're potentially able to change the situation into your favor. And the story I like to tell is a story of two graduate students that came up with something that we all use today, that are, you know, multi-billionaires off of it, but they had the same situation. They somehow were able to change that situation to make them extremely wealthy today. And so,
Because they understood the value of what they were building.
they understood the value of what they were building. Also, I think the university was very favorable to entrepreneurship, tech entrepreneurship specifically. So there are two Stanford students, PhD students. You know, one was working on cataloging the internet, you know, cataloging pages on the internet. He had this thing called PageRank. He was trying to, and it was working okay, but he wasn't a data scientist. He was logging the pages and he had something he was doing. And there was a new grad student named Sergey. Sergey was a data scientist. He would run these algorithms. He could simplify these things. And so a mutual connection said, hey, Sergey, this has got Larry you need to meet. Larry's doing this perfect work. I think your data analytics and science would be perfect for what he's doing. You all should meet. They met, they hit it off, they saw the value, they started working on it, and they said, Stanford, can we use your service? Can we test this on campus and see how it works? So this PageRank program was working on campus. They were overloading the servers. So they said, if this is this much, we're just working on the college campus, we might actually have a business here. And so they negotiated out of that agreement for $50,000. Stanford said, okay, you pay us $50,000, and you're going to create a company, and you're going to give us stock. And if you hit these different benchmarks, then our stock value will appreciate to this percentage. And so this company is called Alphabet Inc., which owns Google. So Larry Page and Sergey Brin are the founders of Google. And this was their search algorithm for the internet that started everything. I want to say Stanford got $50 billion out of that.
Wow.
And I don't know how many, I don't know, 100, I don't know what their value of what their stock and their wealth is now, but I mean, Android, Google, all the things you can think of that come out of that ecosystem. Think about how much we would have lost had they not had the foresight to understand the value of their IP, and if the university had not been willing to work with them. So how many of these ideas are cut off because we're focused on just getting to the degree and we're not thinking about the value of what we're creating? They didn't graduate from Stanford. They have honorary degrees, of course, but they're board members and everything else, but they didn't graduate. They pursued their idea and leveraged intellectual property. So that's an example I like to give.
Wow. And that brings us back to, again, what we started with. Is it $1 billion idea? Right? If what they were creating wasn't Google and it was something else that perhaps they could maybe make a living from, a typical living from, then they would have had to evaluate, is it worth going through all this trouble to create this, to just have what essentially is a job? We created our own job.
Right.
In that case, they probably would have said, well, let's go ahead and get our degree. And, we'll keep this on the side, but we're going to get our degree because we might need a real job one day. Right.
Right. And you have to evaluate that. So one of the questions that we ask, what's the market for this? What's the market for this?
Exactly.
And these are implicit questions, with the patent and trademark office being in the Department of Commerce, it's implied that there has to be some commercial value, but we're thinking about, I love my idea. And I think you had to step aside. I love my idea. Does the market love my idea? Exactly. I tell people, has anybody else tried to do this? And people say, well, if somebody's trying to do it, I don't want to get a patent on it. If you have one of the indicators, if I'm searching, I find multiple patent applications. One thing I know is it's at least a market for it. Right. Somebody's invested in it. There's a reason. There's some value here. Now, then we have to see, is what I'm doing new? And then, a good metric that, there are different metrics. You want to see how quick, can I go from $0 to $100,000 on this? Is it that valuable? If I can say, with my MVP, my minimum viable product, and my prototype, if I can sell some kind of solution with this, how quickly could I go to $20,000, to $50,000, $100,000, and then work backwards from there? Okay, if I can get to that number, how can I? Because your IP protection is an investment, but you shouldn't be investing $100,000 in IP if you're only going to make $100,000. It makes no sense. Right. If you're going to make $1 billion, you say, I'll invest $100,000 in this IP. It makes sense.
Exactly.
And I think sometimes
you got to test that market.
Yes.
So many people invest $100,000 and more and never have done a test, right? They never did a focus group. They never just put a bunch of people in a room and say, hey, you guys like this? So tell me what you think. Right. So we always try to encourage people to actually get out there, like the folks, like the two guys at Stanford. It worked for Stanford and it worked very well. So they knew what they had. Right. And they weren't just sitting in their own living room saying, oh, this is going to be the greatest thing ever. Like, they
And
knew
we have to think
exactly what
about
they
the,
had because they put it out there.
yeah, if you think about the market, I mean, some of us are old enough to remember before Google, what the internet search was like. You could go to Yahoo, you could go to what was it,
Yeah.
Metacrawler, Alta Vista, all these different searches.
Jeeves, you had
Yeah.
Ask Jeeves.
And everything would give you a different answer. There was no,
Right.
I mean, and I was like, well, how are they coming up with this stuff? There was no way of really evaluating the rest of the information. So Google has done a very good job in it with their analytics to continue to be able to get the most useful information first. There might be some politics, they might keep some stuff off, who knows? But I mean, at the end of the day, it's much better than what was before. So you have to create something that has value. You have to have something, and it's not, they didn't invent searching, but they did it better. And they continue to do it better. Just like Facebook isn't the first social network, but they're doing certain things better. And so that's what we have to look at. Is it better? You have a market for it. And then you have to do a cost benefit analysis.
All right. And Tariq is here to help anybody who's interested in doing that. I guess, Tariq, can you put your information in the chat or in the questions and answers? So you definitely want to reach out to Tariq if you have some further questions. There are no other questions in the Q&A that I can see. So I'm going to wrap this up at this point. I want to thank you for your time, Tariq. I'm going to thank all the folks that joined us today. I want to thank the Small Business Resource Center, Paul Taylor and his group, Lisa Edwards for helping us out and setting this up. All the folks over there at Baltimore City government, thank you for allowing us to use your platform. I'm happy to have been able to share this information. Again, I'm Jim Peterson. You can catch me at M&T Bank. I'm at JimPMNT on Instagram and other social media. You can also connect with me on LinkedIn. Happy to help you in any way that I can. And Tariq is putting his information in the chat. If you can go to the chat, you can get Tariq's direct contact. You can connect with him on all his social media and LinkedIn as well. And we want to thank you. Thank you for joining us today. And we hope to bring you some, look for us coming for the rest of the summer and going into the fall. We're going to try to bring you some great information. And if there's anything in particular that you guys want to see, then please be sure to reach out and we'll try to bring you what you need.
Right. And we'll send you we may follow up and send you a link or a questionnaire after this, just if you want to schedule consultations. We do have a free consultation and with attended or registered for this meeting.
Yeah, so Tariq and his folks will reach out to you, and he'll also let you know this has been recorded, and he'll let you know where you can find the link to the recording. So if there's anything that you missed or you want to go back and see some of the answers to some of the questions, that was recorded, wasn't it, Tariq?
Yeah, everything was recorded.
All right. So at some point in the future, we'll let you know where you can get access to that link.
All right. Thank you all so much.
Thank you, guys. Have a great day.
Okay.
Thanks, Tariq.
Thank you, Jeff.